When one commits a crime, they've automatically enrolled themselves in criminal justice school, and the main student focus is themselves. Fighting criminal cases are no joke and definitely shouldn't be treated as one, or a defendant could find themselves suffering for years due to improper knowledge and handling of the case. You own your criminal case, and ignorance is no excuse when the knowledge is there to be researched and the court process is fully broken down. Your lawyer, your family, or your friends are not the ones in trouble. You are, and you have to take every precaution necessary to see to it that you don't get railroaded in the end. People fight criminal cases every single day of all kinds, and every case is unique. So you have to see what are the facts in your case and the proper way to defend yourself, as you are the only one who will deal with the punishment, if any. It's not the end of the road just because you have a criminal case, but it is very costly to be inattentive, uninformed, and not involved actively with the process. Once you're sentenced and serving time or doing programs that you later on found out didn't have to be so severe or even served at all sometime, then you'd wish you were more alert and productive. By then, it'll be too late. Care about your criminal record and the outcomes of accusations as much as you care about anything else that means something to you. Once you let it get destroyed, it will be damaging to your reputation in society and your name overall. These records are publicized, and it's better to fight to clear yourself or at least get better, more favorable results. This list hopefully will help you see the mistakes that can cost you dearly and why if you don't take your criminal case seriously. Attorneys and public defenders are there to serve the same purpose, except whether they choose to admit it or not, they handle cases differently. A paid attorney works a little better for you than a state-paid public defender who's really there to defend you just enough to get a final decision in the case. To put it simply, if you are facing serious time and there is enough evidence against you to defeat you in court, a paid attorney is the way to get a much better sentence, depending on the severity of your case, and someone to work harder to get more favorable results. Sometimes they'll get cases dismissed or charges lowered for you. A public defender is good for lighter misdemeanors and low-level felonies that you are sure you're guilty of and don't want to go to trial with. Cases where it's easy to win in your favor also can be decided effectively with a public defender. If you try to go to war with the public defender just because you're unable to afford a paid attorney, you greatly risk the chance of losing it in a much harsher sentence. Paid attorneys aren't all that necessary when you're just looking for a reasonable guilty plea for lighter crimes, but definitely use caution. Sometimes you can pay a lawyer thousands of dollars for the same outcome you would have gotten with a state-paid public defender. One way of weighing your options better is to start with the public defender and see what they dig up in the case and offers they get from the prosecutor before paying a lawyer. Then take those offers to a potential paid attorney you'd hire and see if they could do better. Do this only if you don't have the money right away for a lawyer. But if you do and your case is serious enough, don't waste time and just pay the lawyer. Criminal cases are serious because they cost you your freedoms, your time, and complicate your day-to-day life after decisions are made with findings of guilt. Your charge and information should not be taken lightly, and you need to learn every single meaning of every word they read in court regarding what you're being charged with. The words knowingly and intentionally are especially important, as that just may not be true and cause for dismissal of the case. Also, studying other similar cases, circumstances and outcomes, appeals, and questionable situations help to enlighten you on how to effectively view your individual case. Ignorance to the law will never be an excuse in court, and you should actively familiarize yourself with all they're laying out as your charges, the amount of time it carries, how it can be defended against, possible reasonable negotiations, alternative lower charges that relate to the circumstances that initiated a criminal case, questions and work for your attorney, and what does and doesn't apply to you. Proactive approaches by you are very necessary, and trial procedures need to be learned as well to understand how the case will move through the court and the time frame for pertinent information and necessary motions and petitions that need to be filed. The less you know, the more you'll be fooled and confused in the end. The more you learn, the better you'll feel with your defense and the outcome. It will be easy to see when you don't know anything that's going on and months have gone by that you could have educated yourself while court proceedings were being held. Attorneys are there to defend you, and they're held to higher standards of practice morally and lawfully, but you have to understand that ultimately it is your life, your case, and your freedom that is on the line, not theirs. Also, you aren't in the relationship with them because you work for them, they work for you. The involvement needs to be treated exactly that way too, and people put themselves at a great disadvantage by putting too much trust in their attorney and his or her decisions without challenging anything or understanding fully of why they feel certain steps are best to take. Part of this is because of people's ignorance to the law and the overall court process and procedures. By no means should a defendant sit back and let a lawyer decide everything without learning for themselves what is going on now and what is expected to come. When you let a lawyer see that you aren't trying to be actively involved, they'll make any and every decision for you, and that can turn out to be a nightmare. Later on, when it's too late, you'll be confused and regretting your decision to be lax. Your lawyer can do it all, but they also are working for you, and your thoughtful and informed input works and could be extremely helpful. Who else would be as serious about your fate than you? Once your lawyer comes to a decision with the state and a judge finalizes it, only you will be stuck with the terms and conditions of that sentence. Brainstorm and communicate back and forth with your lawyer as much as possible until you have all of your questions and concerns handled and explained. You fully understand what's going on and what's next, and most importantly, you're comfortable enough knowing that just anything is going on behind your back that will adversely affect you. Extra attention needs to be used when it is a public defender you're involved with. They seriously aren't putting in the effort you're hoping they would as you would think they are. You better be fully on top of every aspect of your case if you're forced to use a public defender to defend you in your criminal case. It is common for a criminal case to be decided with a plea agreement, but the wrong plea can devastate your future. With respect to classes of felonies and misdemeanors carrying mandatory minimums and maximum caps, and also the circumstances and severity of certain individual facts in the case, just because you plan to accept a plea of guilt doesn't mean that you have to accept what they offer you without at least negotiating for an outcome that would be more favorable for you. As long as you are in between the minimum and the maximum of what you're pleading guilty to, the plea can be arranged in many variations, including all suspended time to probation to a little executed and a little suspended time. Executed time to alternative programs and more can be negotiated, but won't happen if you don't try. Sometimes the only way to get a better plea is to not accept what was offered and negotiate better. Failure to negotiate has had thousands of people doing more time than they would and accepting terms and conditions they wouldn't have to had they just took the opportunity to negotiate with their lawyer a suitable proposal they could share with the prosecutor. In all actuality, it is considered a deal, which means they're offering something in exchange for something, which is your guilt and freedoms. You might as well negotiate before you give these up so freely and be the one who's really going to be affected by the decision. Whether it is your attorney, who may come across as intimidating due to their professional rhetoric and overwhelming knowledge of the law, or in court in front of a judge at any proceeding, if there is anything you are confused about, any questions or concerns you have, any thoughts or any necessary information you need to share, you need to speak up or holding your peace will affect you. When you have your lawyer on the phone or in person, you are on limited time. When you are in court in front of the judge, you have probably less than 5 minutes. You need to say what you need to say. The best way is when you do have questions, thoughts, or concerns to write them down instead of trying to store them until the time you are able to. The reason being is because when you're already intimidated by the people in the process, you are more than likely going to forget or miss what you really needed to say. Again, it is your life. Speak for yourself because no one else will when you need them to. Everything involving a criminal case requires your signature in order to make it legally binding, and defendants make the costly mistake a lot by not paying attention to what they're signing and obligating themselves to terms and conditions they didn't fully understand or acknowledge. Any document you sign needs to be thoroughly read and examined for accuracy and determined by you if you are able to meet those terms and conditions. Disregard, violations, non-reporting, and insubordinate actions due to you signing to do something you don't intend on doing will negatively affect you later. Plea agreements can be disregarded, terms and conditions can be modified in some cases, and even pretrial bond requirements can be redetermined by a court order as long as you don't sign and obligate yourself first. Just because you're handed a paper and a pen and told to sign it doesn't mean you have to without fully understanding why and discussing other options before binding yourself to its terms and conditions. Possibly the most costliest mistake on this list is not thoroughly looking over the evidence the state or feds have against you. If you have to read it over several times, then you should absolutely do that. You should never only allow your lawyer to view the discovery and relay the information to you without you physically viewing the same information they have. This includes all evidence in full, all statements, video footage, testimonies, witness and police names, and charging information is in the complete discovery that you should be eager to familiarize yourself with. Without viewing this discovery yourself and discussing its contents with your lawyer, you shouldn't be making any guilty plea agreements or pleading guilty at all. There could be lack of strong evidence and mistakes that could exonerate you, and you give all of that up by prematurely pleading guilty. Knowing the evidence against you allows you to determine how to effectively defend yourself and if you have a good chance at fighting and winning. When you don't know the evidence and the lawyer knows you haven't scheduled to view the discovery, you give them the opportunity to scare you into signing guilt and or doing time you probably didn't have to. Public defenders especially will overlook loopholes and not reveal how weak a case is to get you to sign your guilt when they know you're uninformed or a lack of knowledge of what is or isn't there to get a conviction. They can tell you anything and you'd believe it. Although they never admit this and it is malpractice and unethical, it happens daily and people are doing time and executing sentences they could have had beaten if only they took it upon themselves to learn the evidence they were fighting against. You know what comes with catching a case and have familiarized yourself with what the potential outcome could be. And if it isn't light punishment that will probably just lead to probation for a short time, then you need to be sure you have plans in place, or the failure to plan will cause you to lose it all if it goes bad. Anything that can land you in jail is enough to start protecting what you need to survive outside of jail. Your house, your cars, your kids, your livelihood all need plans put together on how they'll be sustained properly or risk everything falling apart or being lost. Some of this can be prevented with much less headache when already prepared. Jail stays come unexpectedly and at the worst times, which is any time. And it's super tough trying to keep control over a jail phone.
You got a problem me answering the phone all of a sudden?
Is this Jody? The Jody that got my boo pregnant and can't take care of his responsibilities as a man?
Finding out does not mean you're free, and oftentimes people mistake bail for freedom although specific restrictions were put into place for them to abide by, and they violate them anyway and land in jail pending the outcomes of the pending case. That always comes at a horrible time, and most counties don't let you have a second bond, and you'll be lucky if they release you again on pretrial. Not maintaining good behavior during the pretrial phase traps people up all of the time, and when they're sitting in jail, they want to get out so bad they wind up hurrying and accepting any plea agreement they can to speed up that process. This causes people to sign wrong deals and set themselves up for failure in the near future.
Man, I'm gonna go over there and talk to him.
No, fuck a talk. I'm driving up there and I'm gonna take him out before he rats us out.
It's not worth it to do anything they said not to do as a condition of bond, because you'll get caught up eventually in jail, and you can't do none of what you did to violate in jail. It also makes it harder to effectively fight your case how you need to from behind bars. When we catch criminal cases, it's because of activity that we're involved with excessively that we shouldn't be, or it is activity that is powered by stuff we shouldn't be doing. Either way, we'll keep fighting similar cases if we don't realize what is the root issue and change it. The jail and the court system has revolving doors with no age limits or cap on how many times you can walk through it, and people, the same people, continuously keep themselves in battle because they keep thinking they can do the same things and expect different results. The problem is they land themselves right back in court on new charges to deal with. When one is truly tired of this game, they can never win, they'll change the action and possibly never come through the system again. It takes one to acknowledge where their problem lies first and be willing to change it and end the insanity that makes them believe they're slicker and smarter this time and continue down a destructive path.